Good afternoon to those of you who are already here. I'm just going to wait a couple of minutes because there's still a few people joining in before we get started. Okay, so just whilst people are still joining, a couple of housekeeping matters. I have hopefully set it so that everybody's microphone should be on mute as you join the meeting. If you could keep them on mute unless you want to ask a question, that helps to avoid feedback. If your camera, if you want to have them on, that's absolutely fine. It's quite nice to see that people are actually there. But if you don't want to have it on, that's also absolutely fine. And I think I've set it ordinarily so that they should start with being off. So as I say, it's up to you. As we go along, if you have any questions, please pop them in the chat if you can, and we will have a look at them as we go along, and we'll answer them as and when appropriate. I'm joined, oh, sorry, just there's quite a few people still arriving, so I'll just hold on a second. Okay, let's try now. So welcome to those of you who've just joined. All you've missed so far is housekeeping, which is if you could please keep your microphones on mute to avoid feedback. If you want to have your camera on, that's fine. If you don't, that's also fine. Any questions are very welcome. If you'd like to pop them in the chat, we'll address them as and when we can. I'm joined this afternoon by Jasmine Skander, who you'll see shortly. You'll be able to see her at the moment as well. She and I are both members of the PI and clinical negligence teams at King's, both practicing in a mixture of PI in clin neg and abuse. Jasmine has a particular focus on criminal injuries compensation, as well as the PI and clinical negligence work. Both of us act for claimants and defendants in these cases. And what we're going to do this afternoon is take you through the key recent cases broadly over the last 12 months. A couple of them, I think, extend slightly outside of that. But what we decided to do is break it down into themes. So Jasmine's going to talk to you first of all about limitation. And then I'm going to talk to you about vicarious liability. And I'm also going to talk to you about consent. We'll be recording this afternoon, and the recording and the slides will all be available afterwards from Chambers if either you want them or if colleagues want them. So having said that, what I'll do is I'll switch off my camera and I'll hand over to
All right, hello. I hope you can all hear me. If you can't hear me or anything comes up during the process of my section of the talk, please just drop me a message and we'll go back to Richard because he's in charge of it. And I hope you can all see these slides up on your screen now. So I'd like to start looking, dealing with the cases and specifically with limitation. There are obviously a number of cases in respect of limitation, and I thought it might be useful for us to have some time looking at the case of FXF. It's a case where the judgment was handed down only on the 2nd of April this year, so really very recent indeed. And if we could go, thank you, Richard, first slide, thank you. So just by way of background, this is a case where the claimant came from a devout Catholic family, and she alleged that she'd been abused by the priest who'd been assigned to the local abbey. And the abuse she alleged took place between 1968 and 1969, when she was around 4 to 5 years old at the time. And the abuse, she said, also happened to her sister. The priest was one Father Webb, and the claimant's case was that she disclosed that Father Webb had been abusing her and her sister, and she disclosed that to her mother, but she wasn't believed at the time. Now, it was her case that the mother discovered the abuse, and the claimant's father was advised what happened, and the father asked the priest to leave, and the family thereafter relocated and moved away. Now, the claimant's mother died in 2004, and that's really a summary of the background. But in terms of limitation, following dates are key. As I say, the date of the abuse was 1968 to 69, and that meant that the expiry of the limitation period was in 1985. Now, Father Webb dies in 1990, so 5 years after the expiry of the limitation period. Solicitors are first consulted, and apologies for the typographical error there, in March 2013, and the defendant is first notified in July 14, and in this case, notifying the defendant involved reporting it to the National Catholic Safeguarding Commission, and then they passed it on to the safeguarding coordinator that was engaged by the defendant. It was issued in September 17, that's some 32 years and 9 months after the expiry of the initial limitation period. And as we often see in these cases, the claimant sought the necessary direction in the particulars of claim to set aside section 33. And the claimant's case was effectively twofold. Firstly, that there was a good reason for the delay, and also the cogency of the evidence hadn't been diminished. Unsurprisingly, the defendant argued that Father Webb's death in 1990 caused significant prejudice, and a fair trial was no longer possible. So obviously, the court had to consider the Limitation Act, and the 1980 provision was key in this case. If we can have the next slide, please, Richard. Thank you. I'm not going to take you through it. We all know what it says, but I've set it out there just for completion. If I can go to the next slide, please, Richard. Thank you. And again, the next one. Wonderful. Thank you. So the headlines, or Mrs. Justice Lambert reminded herself of the summary that's set down by the Master of the Rolls in the case of Greater Manchester and Carroll. It's a case that anyone who's dealing with limitation will know. So again, I won't take you through it in too much detail, but it's useful to note the following key factors: that there is no one circumstance that will predominate. So in essence, what the judge was saying is there's no fetter on the court's discretion. It's a wide discretion, and it's based on the court's experience and also their evaluation of their experience as against all of the different circumstances in the case. And it's a balancing exercise. And when we talk about balancing exercise in terms of limitation, the heart of it really is balancing exercise about prejudice. So looking then specifically at that balancing exercise, if I could have the next slide, please, Richard. Thank you. It's useful to note where the burdens sit, and it's very helpfully set out again in this case. Obviously the burden of establishing, the burden of establishing where the balance lies is obviously on the claimant, and as we know, it's not necessarily a heavy one. So there are cases, for example, where the facts are very strong, where the perpetrator has a conviction for the offences, where the burden is obviously a much lighter one, although it still sits on the claimant's shoulders. But the evidential burden of showing that the evidence that's adduced or likely to be adduced by the defendant is less cogent is, for obvious reasons, one that sits on the defendant's shoulders. And as we'll see in this case, it really did turn on that burden.
Sorry to interrupt, Jasmine. There's been a message to say that the sound is breaking up. Could I just ask that some of those of you that have got your cameras on, could you just give us a thumbs up if you can hear okay? And I've got a few, so okay, it looks like it might be an individual problem. It sounds okay at my end, so sorry, I'll let you carry on. If anyone has a problem, just say so in the chat and I'll look into it and see what I can do.
Great, thank you, Rich. I think this is also being recorded, isn't it? So I think we can send it out to anyone who's had any difficulties. Great, thank you. If I could just have the next slide, please, Richard. Thank you. So this case is a useful case to look at, not just because it's so recent, it's a High Court decision, but also because there's a useful kind of refining of the test here. And we'll look at 2 points specifically: the length of the delay and the reason for the delay. And in terms of the length of the delay, obviously, once limitation period is expired, it becomes relevant, as we know, to consider the whole of the period that's elapsed since the cause of action accrued. We know that from Donovan, Catholic Child Welfare Society, and CD 2018 case from the Court of Appeal. Useful also to remind ourselves of the reason for the delay, and it's obviously described in this case as a subjective inquiry. And there's an assessment by the court as to whether it's a good or a bad reason, and whether the claimant can be described as culpable in the delay. And if it's excusable, then it may assist the claimant when considering whether it's fair and just. And those arguments, at least for my part, are difficult to reconcile with what we might describe as a defendant's perspective, which is that, well, however excusable it is, if the defendant doesn't have the evidence available, then the prejudice still is obviously very, very high in terms of the defendant's perspective. So it's difficult, but this is the decision, and obviously it pulls together decisions from higher courts as well. If I could just have the next slide, please. Thank you. So the evidence, well, the claimant obviously provided her own evidence. There's also witness evidence in this case from her sister, from her father. Now, her father, as I said at the outset, didn't witness the abuse, but he was obviously advised of it by his wife, and consequently asked the priest to leave. And there were 2 other alleged victims as well. And we also had, in this case, some of the counselling notes, and it's useful to read the case as well in respect of the diary entries. There were some diary entries, but there was an issue in respect of disclosure of them that features in this case. Now, the reasons for the delay, well, this is key. The claimant came to court with a variety of different reasons. One of them was the mother's view of what had happened, how religious she was, how detrimental it would have been for her and the claimant's relationship with her if she had attempted to bring the proceedings before, or she had talked about what had happened to her before. So that was one reason that was given. Another reason was that the surname of the priest wasn't known to the claimant at the time, and in fact it wasn't known until 2012, although there was relatively poor evidence, I would say, in the case in respect of what the claimant had done before that time to try and obtain the surname of the perpetrator. And then there were 2 triggering events, one in 2013 and one in 2016. The one in 2013 involved the claimant finding out that I think it was her brother-in-law had been abusing her niece, and that triggered the memories for her, and that resulted in the claimant seeking some advice. But when the claimant sought advice from the solicitor, she read the terms and conditions and she realised there could be a financial penalty in respect to bringing a claim. And so she didn't pursue it any further at that point because she was a single parent. And then there was another triggering event in 2016 when she watched a particular film which had elements of abuse in it that were similar to what had happened to her. And these reasons were effectively assessed, as we would expect, by the judge. If I could have the next slide, please, Richard. Thank you. Obviously, the defendant's evidence was very limited indeed. As I said, Father Webb died in 1990, 5 years after the expiry of the limitation. There was an investigation report, and both parties relied obviously on forensic expert evidence from forensic psychiatrists, but obviously the evidence from the defendant's side was limited. So the next slide. Thank you. The question on limitations really helpfully set out in this case, and it's at paragraph 100. And Mrs. Justice Lambert says, the question ultimately for me is whether the reasons which I have found for the delay as a whole qualify or temper the prejudicial effect of the delay on the defendant's ability to defend the claim. And if I could have the next slide, please. Thank you. And it is that question that was obviously at the heart of the decision-making process. And there were various peripheral points in the findings in this case, and they're useful to some degree. One of the peripheral points was there was some criticism levelled at the defendant by the claimant about the conduct after the cause of action arose, specifically in respect of the investigations that were undertaken, but the court found that was just effectively a non-point, because if there had been any investigations in respect of any abuse to other individuals, the claimant hadn't sought disclosure of those, and the judge just wasn't willing to entertain that submission. The case really turned on that evidential burden that I mentioned at the outset, and the question of whether a fair trial was possible. And the judge found, after a trial of all of the evidence, the judge came back to this particular point, and this is really the crux of the case, that the defendants have undoubtedly discharged the evidential burden by reason of the death of Father Webb. She said, I have found that as a result of Father Webb's death in 1990, the defendant has suffered a very substantial prejudice, and they can advance no positive case in respect of the claimant's allegations. Do we have a slide after that, Richard? Or I think, yeah, that's the last slide. And so FXF is useful, as I say, because it's so recent, 2nd of April 2020, because it pulls together various other cases, and it's useful in respect of how much weight was given to the fact that the perpetrator had died, as against the various different reasons that the claimant presented when she was at trial in terms of the reasons for the delay. Arguably, some of those were excusable. Richard, do we have any questions?
I'm back. Just let me have a look. Bear with me a second. One question. So does this mean where a perpetrator has died that there can't be a fair trial, or that the argument will always succeed on limitation on section 33?
What was that? That there can't be a fair trial?
So does this mean then that where the perpetrator has died, that there can't be a fair trial?
Ah, okay, thank you. Sorry, the signal was going slightly then. No, it doesn't necessarily mean that. Obviously, it's always a question of weight. I think it's paragraph 105, where Mrs. Justice Lambert actually engages with the argument that's put forward by claimant counsel. And just give me one moment. Yes, paragraph 105, the judge effectively says, if the claimant had a very strong case, then this would have weighed heavily in the balance in her favour, but she doesn't have a very strong case. And then there was an argument about the egregious nature of the abuse, and I think there was a parallel was drawn by claimant counsel between A and Hoare, and the judge responded and said, well, effectively, in that case, the defendant had been convicted and sentenced to life imprisonment, so that they're not on a par. And in fact, Richard, one of the cases that we don't have time to look at today, but it is quite useful, is a case called DSN and Blackpool Football Club. It's a High Court decision. The judgment was handed down in March, 13th of March, I think, this year. And in that case, the principles of A and Hoare are not kind of dismissed so readily. And in that case, the limitation defence failed. and effectively arguments such as the shame that the claimant felt, his concern about his mother, his coping strategy by ignoring what happened, all of that was relevant. And in DSN, like in FXF, the perpetrator had died. But unlike in FXF, the perpetrator in that case had in fact been convicted. He'd been convicted closer in time of some sexual offences. And that, I suppose, what our criminal colleagues would describe as bad character obviously weighed in the balance. So in summary, so it's a bit convoluted response, but in summary, just because the perpetrator has died doesn't necessarily mean that it will always tip the balance. DSN's a perfect example of the perpetrator dying, but there's a conviction there. The case is strong in that way. So I think all of these cases are just so fact sensitive that when it's set out at the beginning that there is no one circumstance that rules. I think that my experience, having read all these cases and advised in them, is that has to be right.
Thanks. Interesting. Somebody has pointed out that DSN apparently is being appealed, something that I didn't realise, but that's interesting.
Oh, okay.
I'd be interested to know,
Right.
Chris, who said that, if you know whether, on what grounds, whether it's all of them or just some of them. Another question has been asked, Jasmine. Scotland has abolished limitation for abuse cases. Do you think that's ever likely to happen in England?
No, I don't.
Well, there's a short answer. And do you know a bit of a test there? In FXF, were there any other convictions against the perpetrator?
In FXF, no, I don't think so.
All right. Well, that's the questions that we have. Thanks very much, Jasmine. I'll put you on mute just so that it stays on me while I'm talking.
Thank you, Richard. And just Richard, while you're before you go, your line is, for me, it's breaking up quite a lot, so I don't know if it's doing that for anybody else.
Right. But... Okay. Well, I'll tell you what I'll do. I'll switch to a different internet connection, and I'm sure it will be better that way.
Thank you.
So I'll just give me a second to do that. Right, hopefully that will be better. Let's go back through to where I was.
Yeah,
so, as I say,
it's not breaking up for me.
Good. So thanks, Jasmine. I'm going to cover two topics. One is vicarious liability. Obviously, we've got Mohammed and Barclays to talk about. The other subject is going to be the subject of consent, which until recently there was actually surprisingly little authority on what exactly consent was, but there's been a couple of very helpful authorities recently that give us some really clear guidance on that. So starting with vicarious liability, obviously the classic example, and what I'm going to do, I should say, is just give an overview at first of where we were up to until recently, and then talk to you about what the recent cases add to that. So the classic example given is obviously the relationship between employer and employee, but if it were that straightforward, then our lives wouldn't be so interesting. So the usual test, or the two aspects of the test, are set out quite helpfully in Cox and MOJ and the Supreme Court, which is what sort of relationship has to exist between the individual and the defendant. So that is the relationship between the perpetrator, as it were. And then secondly, in what manner does the conduct of that individual, so the tort that we're talking about, have to be related to that relationship? Most of the cases raise one or other, some raise both of those issues. As far as the first part of that test is concerned, Christian Brothers set out the 5 aspects to it, with which I'm sure you'll all be familiar. The 3 most important of those being whether or not it's undertaken on behalf, of an activity on behalf of the employer. The second being whether it's part of the business activity, and I've highlighted that just to remind everyone it doesn't have to be commercial activity, as in the case of churches, for example. And the third most important one being that the employer has created the risk of the tort being committed. The 2 remaining factors, which are means to compensate and control, were both in Cox said to be of less significance, although they can be of significance, and we'll see in a minute a case in which they did continue to be fairly significant. This, I think, is quite a helpful summary from Cox of the test for the relationship. And it says, as it says here, the relationship is sufficient where they carry out activities as an integral part of the business and for its benefit, and where the commission of the wrongful act is a risk created by the defendant by assigning those activities to the individual. Arms, I'm never quite sure how to pronounce it, is the foster carers case. The few things that were said there, which I think are important to note, it's a couple of years ago now, but useful to remind us what it says. The court emphasised in Arms the lack of any other source of compensation, which, as I've just said, is not supposed to be particularly important, but it was important there. At the extent of the control, the fact that the activity was the care of the children committed to the local authority's care, and the foster parents were an integral part of the organisation of childcare services. Now, those 2 seem entirely consistent with what we've just seen here in the test from Christian Brothers. But the focus on the lack of other source of compensation is slightly at odds with those previous judgments. But I think even aside from that, the local authority would have been vicariously liable in Arms because of these 2, the activity, the foster parents being integral, and by placing for children in foster care, the local authority had created the risk of the harm being done. Quite clearly, the foster parents, well, I say quite clearly, the court felt it was quite clear that foster parents are not carrying on an independent business of their own, which is a phrase to which I'll return in a moment. Barclays, I'm sure everybody is familiar with the background to this case, but just in case you aren't, Dr. Bates was a general practitioner. He had a portfolio practice. He did see patients in the ordinary way. He also did various sorts of medical assessments, examinations, including some for Barclays Bank. The employees were sent to prospective employees were sent to Dr. Bates for a medical examination. Barclays provided the pro forma, so they asked him for specific information. Barclays paid him a fee for each report, but he was free to refuse the work if he wished. He sexually assaulted some of those employees, and they brought proceedings against Barclays. Barclays paragraph 24 affirms what I've just set out to you from Christian Brothers, Cox and Arms, and that the distinction, and what they said essentially was that the distinction between, on the one hand, employment or relationships akin to that, and on the other hand, a relationship with an independent contractor has not been taken away by those cases. So what the court was saying was that the cases either fall into employment, or they fall, as they do in Barclays, into this independent contractor box, in which case there is no vicarious liability. But if they fall in between, then it depends whether or not they are akin or analogous to employment. And in looking at the facts of that case, what the court said in Barclays was that he was not at any time an employee, nor was he anything close to an employee. Now we can immediately see the distinction between some of those cases, particularly the clergy type cases, where one might technically not be an employee, but the practical reality is that to all intents and purposes you are. Clearly that's not the case in Barclays. He was free to refuse an offered examination. He was in business on his own account, and he had various clients. One of those clients was the bank. He was a classic self-employed person. So one can see why he was thought to fit into that latter category. So what this really tells us is that in terms of the first part of the test, there is a clear line in the sand. Employees, clearly, yes, there'll be vicarious liability. Contractors, self-employed, no, there won't be. There is still clearly a middle ground, the most obvious example being clergy. In that case, then the test from Christian Brothers that I've set out with those 3 or 5 factors is the test to apply. And it's a question of the nature of the relationship and creation of risk. So the second, excuse me just a moment. The second aspect of the test is, of course, the conduct or the relationship between the defendant and the wrongdoer, and the wrongdoer and the act itself. The case that's referred to in many of these cases is Dubai Aluminium, which isn't an abuse case, and that sets out the close connection test, which is that the acts were so closely connected with acts the employee was authorised to do that it may fairly be regarded as done by the employee. Now we'll all be familiar with that. I'm not going to spend any longer on that. Back to Christian Brothers. Clearly, where the tortfeasor does something that he is required to do, but in a negligent manner, that's going to satisfy stage 2. But the difficulty, of course, in our cases is sexual abuse can never be a negligent way of performing such a requirement, not least because it's deliberate. So the test in Christian Brothers was that the defendant there created or significantly enhanced the risk that the victims would suffer the relevant abuse. And I think more importantly, that there was a closeness of connection between the relationship and the acts of abuse. And in that case, that was because the abusers were tasked with the role of caring for the boys, including in the dormitories and where they lived. So the relationship was one of personal care. So if we think of doctors, of carers, then we can see immediately that there's that close connection between physical abuse and the nature of the role. As I said, the relationship between them enabled the Institute to place the brothers in teaching positions. They were living on the school premises with vulnerable boys, and there was a very close connection between that employment and the abuse they committed in that context. So, Mohammed 2016 is fairly recent. This is the assault in the petrol station case. It was argued there that the test should be broadened to whether a reasonable observer would have considered the employee to be acting in that capacity. The Supreme Court rejected that, but applying the test I've already set out, the close connection test, they found that there was vicarious liability in that case. Because although slightly odd fact, because it was a vicious assault by the attendant at the petrol station on a customer, what the court essentially said was that what he was doing was still part of his role of dealing with a customer, and considered that dealing with a customer included assaulting that customer, which I've always found slightly odd, but one can at least see that the nature of the relationship with the customer was one that arose from the job, and the assault arose out of an interaction that was part of that job. So I can see how that conclusion can be drawn. We come then to the most recent case, which is various claimants, and again Morrisons, unfortunate for them, which was the data case. The perpetrator, as it was in that case, had access to payroll data. He copied it to his own USB stick, tried to frame another employee and leaked that data to newspapers, all arising out of a grievance he had against Morrisons. What the court said is that the correct test is Dubai Aluminium. It's the close connection test. Nothing has changed that. Nothing in Morrisons changes that. They noted that abuse of children, although this wasn't an abuse case, they did note that abuse of children is not going to be in the course of employment. But courts have emphasised in those cases other criteria, such as conferral of authority over the victims, and the other factors that I've spoken about in Christian Brothers a few slides ago. So applying the test in Morrisons, what he was authorised to do was collect payroll data. The way the claimants put their case was that he couldn't have made the disclosure if he'd not been given the task. But the Supreme Court rejected that and said that mere opportunity arising from the employment is not sufficient. And also mere acts of the same kind are not sufficient. So the act he was authorised to do was to disclose the data to one particular party, to KPMG. What he wasn't just authorised to do was to disclose it to somebody else. So opportunity and act of the same kind, not sufficient. And they noted that there was no case that anyone could identify where there'd been vicarious liability for wrongdoing designed specifically to harm the employer. Although they didn't go so far as to say that there could be no vicarious liability in those circumstances. Interestingly, the frolic of his own test, which I personally remember from the GDL, in relation to people going off driving from home, driving between two workplaces, or driving off the supermarket in between, that test resurfaced and was referred to in various claimants and Morrisons. They referred to a few other cases, which I think it's really helpful to look at. One is Hartwell, which is a case of a Bermudan police officer who, on duty and in uniform, took a revolver, I think it was, or a gun, from the police station, went to a different island that was part of his jurisdiction on an vendetta of his own, which arose from, I think, adultery, and he shot somebody. The court in that case said it was a personal vendetta, and the only connection with his employment as a police officer was a mere opportunity, as we've said here, which is not sufficient, which the Supreme Court said. Now, Hartwell's a Privy Council case, so although it doesn't sound to be particularly relevant because it's Bermuda, it's a very high authority. Warren and Henley's is the driving case that I mentioned that I remember from the GDL, which is about a personal vendetta. No, it's not, sorry. But Warren and Henley's is another assault case, but that one was deemed to be a personal vendetta. Bellman is another assault case. If you haven't read that, it makes very interesting reading. It's an assault at a Christmas party. Essentially there, the connection was that when the perpetrator he punched an employee so that he fell and hit his head and suffered a TBI. At that point, he was acting as the managing director and asserting his authority, because what they were arguing about was an issue in relation to work, and he was exerting his authority in that argument, and that extended to a punch. And we can see how that connection can be drawn. So the actual ratio in Morrisons was drawing a key distinction between on the Dubai test, between cases where the employee was engaged, however misguidedly, in furthering his employer's business, and cases where the employee is engaged solely in pursuing his own interests. They found that Skelton's acts fell into the latter. Now, clearly that test isn't going to be entirely conclusive, because when we come back to look at Lister again, most of the abuse cases are not going to be furthering his employer's business. But it gives us some sort of tram lines, as it were, to look to see where either end of the scale is likely to be, where there definitely will be liability and there definitely won't be liability. So it seems clear that what's now settled is that the relevant test is the close connection test. It's clearly fact dependent. As I said, there are bookends, unauthorised means versus a frolic. Mere opportunity, like in Bellman, that police officer case, is not going to be enough. There's quite a nebulous area in the middle where the question is going to be sufficiently close connection, a causative link, abuse. In abuse cases, about conferral of authority and creation of risk, and just keep thinking back to Lister, which I think is the best way to think about this issue. In Lister, the role involved caring for the boys where they lived, and the physical contact with them, touching them, was a means of doing that, although not an authorised means. The other most recent case is BXB and Watchtower, which is earlier this year. Consider both of those tests. I'm not going to go into great detail because I don't have a huge amount of time. First stage of the test was satisfied because elders are spiritual leaders of the congregation, and the risk was created by assigning those spiritual tasks. On stage 2, this is adults. An adult who was raped by the elder. There was sufficient connection for these reasons: the context in which they met, the status in the relationship, the instruction for the senior elder to carry on the relationship in a sense, that the rape occurred after they'd been out pioneering, which is a central part of the obligations of being a Jehovah's Witness, and that the perpetrator, to some extent at least, considered that adultery via rape would be a means to him obtaining a divorce from his wife. So there was the assaults and his role as an elder were very closely connected. It is really the only way to summarize that. So the final case to look at on this is DSM and Blackpool, which has already been mentioned, and I gather is being appealed. I'd be interested to know if anybody does know what grounds it's being appealed on. Very briefly, this is a scout case. He was a volunteer, but that didn't matter. Almost all the non-paying staff were in the same position, and clearly he would have been carrying out work for the club, and it would have been part of the club's business activity. As it said here, there's no more important task for the club than capturing young players. That's clearly part of the business activity, it seems to me. Stage 2, the court was considering abuse that occurred on a trip to New Zealand, and the court found that it was as close as possible as it could be to an official trip. It was a football tour that was part of his operation as building the allegiance that they needed to build between the young players and the club. The involvement with the boys on the tour and the opportunity he took to abuse them in the course of it may fairly and properly be regarded as taking place in the ordinary course of his work. Why wasn't it a frolic? Well, that's a question to which I don't think the answer is entirely clear. I don't think it's made particularly clear in the judgment. That may well be one of the grounds of appeal. It seems that the conclusion was that his role in taking them also involved a caring for them, like in Lister, and therefore the physical abuse of them was sufficiently closely connected to that. And that would therefore seem to apply on school trips or any sort of trips abroad where someone is taking responsibility for children. So the second topic I want to talk to you about is the topic of consent, which is one that interests me because I have a couple of cases, grooming cases, where this arises where there's no obvious, and I hate the phrase forcible rape, but sometimes it's important, isn't it, to distinguish between rapes where we can identify physical force being used and those where we can't. And in those where we can't, depending on the age and the relationship, sometimes it can be more difficult. So I was pleased to see recently a couple of cases that have helped to clarify this. Now, the background, until relatively recently, there wasn't a great deal. There's something in Clark and Linsell that suggests tentatively that consent is a defence, not a part of the cause of action, but there are views either way. My view is it's a defence for what it's worth, but I would always plead it in the particulars anyway. Clark and Linsell says it must be freely given, and that duress vitiates consent. Submission is insufficient. That's also from Clark and Linsell. And in a case in 1964, a mistaken belief as to the authority of the defendant may destroy the freedom to choose. Now that really is part of the submission point. So the recent cases, I put this one in from 2015 because up until the middle of last year, this was one of the only cases that there was. This is actually a county court case at Judge Platt's in Manchester. The claimant was groomed from the age of 8. The sexual acts occurred from the age of 16 to 31, and the claim was only pleaded in battery, not in negligence. The defence was that all of the sexual relations were consensual, and the court noted that there was no known authority considering the test for consent in the context of grooming. What the court found was that fraud or duress would invalidate the consent, that the claimant had capacity, and that the issue was ultimately whether the claimant in fact freely consented or whether that was vitiated by emotional manipulation. Ultimately, that was an issue of fact, and the court distinguished between these two situations. One was at the age of 31. Important to note that there'd been a break off in the relationship when the claimant had gone to university, and then it had restarted sometime later. The claimant was intelligent, articulate, mature. He made the decision to continue to visit him. He agreed to be photographed naked on a couch. That was distinguished quite significantly from the claimant's position at the age of 16, where there was a high degree of emotional dependency. He remained passive. That arose from the grooming. And what the court found was that there was no consent at the earlier point, but there was at the latter. And one of the reasons I set that out is because it's actually quite a helpful demonstration of the different situations that arise and how the test can apply. So where is the line drawn? I think it's actually more helpful to look at the more recent cases, but what the court noted was that the emotional tie loosened over the years. And when we're looking at him at age 31, the court felt that to say he had lost his ability to make a free choice is unrealistic. Now, that case was appealed. The defendant argued that the court applied the wrong test, although unhelpfully, the Court of Appeal upheld the limitation appeal and did not consider the test on consent. So I don't know what test the defendant said should have been applied, but certainly it wasn't that one. Much more recently, we have the case of FZO, depending if you are, it's an Americanism, isn't it? Is a PE teacher who abused the claimant. The claimant was in and out of the school from 1980 to 1984. But the abuse continued until 1988, when the claimant was 21. The defendant was convicted in relation to the earlier period, in relation to old offences of buggery and other offences. So it's not particularly as helpful as it would be in terms of consent. The claimant said that everything that happened up till he was 21 was non-consensual and arose from the grooming. Interestingly, the first defendant, who was the perpetrator, didn't raise consent, but the second defendant, that was the school, did. The second defendant said everything after school, so after 1984 when he was 13, after 1984 when he was 16, everything thereafter was consensual. And now the judge found that it wasn't consensual because of the grooming. This went to the Court of Appeal, so we helpfully now have what's later described as a definitive review in the Court of Appeal of the test for consent. The first point is it's an issue of fact. The second is the sort of succinct test, as it were, was that a person consents to sexual activity with another if they have the freedom and capacity to consent. Submission is not the same as consent. The Court of Appeal considered some criminal cases. It was interesting to note that they didn't think there was any reason not to consider what consent means in the criminal context when we're looking at a civil context. In CNR, once the jury was satisfied the activity had occurred and that being the earlier activity, impacted on and reflected the appellant's, so the perpetrator's dominance, one could conclude that the evidence of apparent consent that later, when the complainant was not a child, was apparent, not real. So what that really tells us is that earlier events can impact on whether or not later apparent consent is actual consent. Ologboja says every consent involves a submission. Seems obvious, but that doesn't mean that a mere submission is actually consent. So that helps us to understand that there has to be more than just submission, more than just going along with. FCO then says that conditioned consent resulting from a grooming process is not true consent. So if there's a grooming process that affects the perception of the relationship and the power balance, even apparent consent thereafter when the complainant is an adult, if it arises from that, it's not true consent. Submission is not the same, as I've already said. The judge in this case found that the respondent's consent was not genuine, that it had been overridden by psychological coercion derived from the grooming and abuse at the school, and the appeal was rejected. So, as I said previously, that is an issue of fact, but it's also an issue for experts to comment on. And there are a number of experts who are capable of doing that. Psychiatrists, they sometimes, they don't, essentially, in the end, they have to defer to the judge because it is an issue of fact, but they can assist in terms of the nature of a relationship and how it's developed and how that can impact on the perception of the relationship going forwards. So the next case, and I think potentially the last case, is EXE, another 2020 case. Shortly after the case of FZO, this is a High Court case of a schoolgirl abused by a teacher. There was a very long judgment because there's a huge factual dispute about what exactly happened. It wasn't originally suggested that, it wasn't initially suggested that there'd been a forcible rape, and then later it was. Importantly for defendants, it was said that it might be argued that no child under 16 can consent, but that is not the law. As we've just seen in the previous cases, it's more complicated than that. The court followed the guidance that was set out in the FZO. And the claimant was saying that there was passive coercion, and that with hindsight being older now, she said she could see that he used love to manipulate me. And I now realise that I was only doing what he told me to do. Because she told the police in the late 80s, I think it was, that everything was consensual and it was all her own free will. And she now says she was doing that to help him, which seems to me, I can understand that. The court rejected that. This is on the facts, and found that at the time she knew what she was doing. She wanted to do it at the time without being groomed and without her free will being undermined. She took the initiative, and if anything, was making the suggestions, because she had suggested, for example, that they meet at different times. Now, that seems to me a difficult conclusion, because one has to also accept that she was still a child, and although she may have very much desired the relationship, one gets into very difficult judgments there about the extent to which someone of that age is capable of understanding the relationship, and whether that relationship is genuine, whether it is a genuine relationship of love and affection, or whether it is one that arises from abuse of authority and power. So I think there's more to be said as things go forward. This is an area that I think there'll be more cases, there'll be more authority, things will develop, but the most important thing is that we've got some helpful indication here in FZO as to what the test is. So we've got some idea where we're going forwards. So that's all the questions. That's all the cases I was going to cover on consent. If anyone has any questions, do feel free to pop them into the chat. I don't think there have been any yet. I'll just give everybody. Someone's clarified that I said earlier wrongly that Scotland has abolished abuse limitation. In fact, I'm told that they have abolished childhood limitation. I don't profess to be an expert on Scottish law, but that's interesting to know that there apparently is no childhood limitation. Something worth looking at, I suppose, if you're doing cases in Scotland. So I haven't seen any questions. If anybody has anything they want to ask me, then I'm certainly happy for them to drop me an email. As I said at the beginning, the video that I'm about to make will be available if anybody wants it, or if anybody's colleagues want it. Slides will also be available if you want to see those. And if Jasmine or I can help on anything on these issues, then I'm sure we'd both be very happy to answer any questions anyone has by email. So we'll both hang around for a couple of minutes and let you leave as and when you want, and to give people a chance to type out any questions they're asking. And I can see, it looks like one has come in now. Two very interesting points. Okay, so one point that someone makes is that the main difference between FZO and EXE was that in the latter there was a contemporaneous statement which said that the relationship was consensual. As I've explained, the claimant said in that case that the reason she gave that was to protect him. The person who said this quite rightly says this only goes to emphasise the importance of contemporaneous documents and looking at exactly what they say. Lucy, hello Lucy, has asked, have either FCO or EXE defined grooming? The answer is no. What they have really said is, as I've set out, if the relationship or the history of abuse or whatever it is has impacted on the ability to consent or on the perception of the relationship, then it can vitiate consent. Nobody yet seems to have been able to define how that happens. So that, I think, is one area in which there'll have to be some further litigation and some further authorities, perhaps even higher than that. Looks like those are all the questions. So unless, Jasmine, you've got any questions or anything you want to add, I will let everyone go. Okay, so we've got some more questions coming in. I'll stay here for a second. How old was the victim in EXE? That is a good question, which I will have to check for you, and I'll do that right now. Whilst I'm doing that, I will just look up the other question. Oh, someone has said, there we go, 1 month shy of her 15th birthday. And that's at the time when it started, and then that continued for some years. And that's the claimant who the court said she was initiating things, she was arranging meetings, things like that. So another question is, I have cases where a child in foster care has been abused, but by friends or relatives of the foster parents, not the foster parents themselves. Do you think liability extends to negligence on their part rather than just assault? Let me think about that. So if the foster parents negligently, well, the foster parents will owe a duty of care to take reasonable care for the safety of the foster children. But then the first thing we have to consider is that we're talking then about liability for the acts of a third party, which is a GN and pool type issue. And I'm thinking on my feet here, but I suppose taking a child into foster care is an assumption of responsibility in terms of GN and pool. So if there were then, if they were abused then by a third party, I suppose you could argue they would be liable. I think if you could establish liability on the foster parents, then I don't see why you couldn't establish liability on the local authority, because they're vicariously liable for them as foster carers. And if, as the question asks, in the context of that foster care, they're abused by somebody else, and that is a result of the negligence of the foster carers, then I think they'd be liable for it. Whether or not you could get over the difficulty of GN and pool, I think I'd have to have a bit more of a think about. Jasmine, do you want to add anything on that?
Well, it's just a minefield, isn't it, Richard? I know we've done a talk on it quite recently, so if anybody's interested, I'm sure we could look at that again. But it's it's a point that raises so many different cases and so many different arguments. It's quite difficult, I think, to kind of summarise it in one go. It's a typical lawyer's answer, I'm afraid.
Yeah. I think that, as I'm thinking about it, I think someone has said, as Lisa said in the chat, yes, it would depend on the facts. Yes, I quite agree, it would depend on the facts. But if we think about the duty of care test, I think the foster carers, by taking children into foster care, are assuming responsibility for those children. I don't think that would be.
Yeah, but if there's third parties who are then abusing those children, then they've got all those arguments, Dorset Yacht Club and Jess.
It depends, I think, on breach of duty, doesn't it? If they know or ought to know that the third party is someone who is likely to abuse the children, then it might be negligent to allow them to contact them. But it would depend whether they know that, and they may know that, they may not know that. So as Jenny says, it depends entirely on the facts. But that's a very interesting issue that might arise. Someone's iPhone says it depends also on the level of knowledge. So I completely agree. If the foster carers are fully aware of who these people are, or ought to be aware, then yes, I think they would be liable. Some interesting questions. Anyone? I'll wait another minute to see if anyone's got any more. I realise people have got things to get on with and childcare to juggle. So if people want to leave, obviously you're very welcome to do so. And I'll just wait here. We'll see if we get any more questions. And Jasmine, if you can, I'm sure you'll wait too. But otherwise, thank you very much, everybody, for coming. And we'll share the video and slides later.
Thank you.